330.10. Upon the verdict of complete acquittal, the court must immediately blank the defendant if he is in custody, or if he is at liberty on bail, it must blank the bail.
Discharge defendant, exonerate bail.
Correct. 330.20. Procedures following verdict or plea of not responsible by reason of mental disease or defect. 320.20. Blank means a defendant currently suffers from a mental illness as per the mental hygiene law, and also because of such condition, he currently constitutes a physical danger to himself and others.
Mentally ill?
That's a dangerous mental disorder. That's a dangerous mental disorder.
Okay.
Mentally ill is actually the next one I'm going to tell you.
Oh, okay.
Mentally ill means a defendant currently suffers from a mental illness for which care and treatment as a patient in the inpatient services of psychiatric center under the jurisdiction of the state mental health is essential to such defendant's welfare, and his judgment is so impaired that he is unable to understand the need for such care and treatment, and where a defendant is mentally retarded, mentally ill shall also mean the defendant is in need of care and treatment as a resident in the inpatient services of the developmental center or other residential facility for the mentally retarded and developmentally disabled under the jurisdiction of the State Office of Mental Retardation and Developmental Disabilities.
Okay.
His judgment is so impaired that he is unable to understand the need of the care. He doesn't even understand why he needs care. Mentally ill also means that he is in need of care and treatment as a resident in an inpatient service of developmental center or other residential facility for the mentally retarded and developmentally disabled under the jurisdiction of the State Officer of the Mental Retardation. I think we would recognize that.
I hope so. I think the key is knowing that this one is not, it doesn't say danger to himself.
Now, the next definition I'm going to give you is if somebody is mentally ill, the thing that I just described,
okay,
or has a dangerous mental disorder, the first one I just described, an order blank means an order directed to the commissioner, requiring that a defendant submit to a psychiatric examination to determine whether the defendant has one of those things, a dangerous mental disorder or is mentally ill, is not dangerous. And what is directed at the commissioner?
The examination?
Yes, it's an exam.
Totally order. Just guessed. All right.
An examination order. An examination order is when it's to find out if somebody is either dangerously mentally disordered or just mentally ill. Blank or blank means an order committing a defendant to the custody of the commissioner for confinement in a secure facility for the care and treatment for 6 months from the date of the order.
A commitment order. Commitment order?
It's a commitment order? I don't remember. You're right, it's a commitment order. And the recommitment order is an order which is effective at the expiration date of the commitment order or another recommitment order. And a recommitment order is for how long?
6 months.
That's also 6 months.
Oh, I totally just guessed.
Yep, so the first commitment order is 6 months. They can apply, it says here, I don't know how they do it, but the commissioner can, I guess, I think it's like 30 days before it expires.
I'm sure we'll get to that.
Yeah, something like that. Okay, blank means an order directed to the commissioner requiring that a defendant submit to a psychiatric examination to determine whether the defendant is dangerously mental disorder or just mentally ill.
Examination order.
Great. Blank or blank means an order committing a defendant to the custody of the commissioner for confinement in a secure facility for care and treatment for 6 months from the date of the order.
Commitment order.
It was blank or blank, and I was looking for commitment order or recommitment order.
Oh, okay. Commitment. All right.
Or, okay?
Okay, and they're both 6 months.
They're both 6 months, right? Now, the first retention order is the one that I was saying is effective at the expiration of either the commitment order or the recommitment order.
That's 1 year.
Right. So they can only get one recommitment order. You get it?
Yes.
Now I'm reading it right.
I
So
get it.
First commitment order is 6 months. Second recommitment order is 6 months. Then you got to get a retention order.
Then you got to get the first retention order.
And the first retention order is for how long?
1 year.
Right. And then blank is an order which is effective at the expiration of the first retention order.
Second retention order.
And the second retention order is for how long?
2 years.
Perfect. Now we got it. And blank means an order which is effective at the expiration of the second retention order or a prior blank authorizing continued custody of the defendant by the commissioner for a period not to exceed 2 years.
Subsequent?
I think it is a something like a continued retention order or something.
It's subsequent.
Subsequent, that's the word.
Because I did these last night, so.
So subsequent retention order means an order which is effective at the expiration of the second retention order, which the second retention order was 2 years. A subsequent retention order is how long?
2 years.
Right. Blank means an order directing the commissioner to allow the defendant in confinement pursuant to a commitment order, a recommitment order, or a retention order to temporarily relieve the facility for a period not to exceed how long?
Do you know?
I'm looking at the answer, but I do know the answer.
Is it 14 days?
Yes.
Okay.
Either with or without constant supervision of one or more employees of the facility. Blank means an order directing the commissioner to transfer the defendant from a secure facility to a non-secure facility under the jurisdiction of the commissioner or to any non-secure facility designated by the commissioner.
Is it a transfer order?
Transfer order is correct.
Okay.
Blank means an order directing the commissioner to terminate a defendant's inpatient status without terminating the commissioner's responsibility for the defendant.
Release order.
Correct. Blank means a physician who is a diplomat of the American Board of Psychiatry and Neurology, or is eligible to be certified by the board, or is certified by the American Osteopathic Board of Neurology and Psychiatry, or is eligible to be certified by the board. I think.
Do you know this?
I think it's something like a qualified something or other.
Is it like a qualified examiner?
It's a qualified psychiatrist.
Oh, okay.
Okay. Upon entry of a verdict of not responsible by reason of mental disease or defect, or upon acceptance of the plea of not responsible of reason by mental disease or defect, the court must immediately what? Issue what?
An examination order.
Yes!
Yay!
Upon expiration of the examination order, and just throwing this at you real quick, how long is an examination order?
30 days, but you can get an extension for 30 days, I think.
I'm still coming up to that, but I just felt like throwing that question out.
Okay.
Receipt of an examination order. The commissioner must designate 2 qualified psychiatric examiners to conduct an examination of the defendant. The clerk of the court must promptly forward a copy of the examination order to
the Mental Hygiene Legal Service.
And such services may thereafter participate in all subsequent proceedings. Confinement in a secure facility pursuant to an examination order shall be for a period not exceeding
30 days.
Correct. Except that upon application of the commissioner, the court may authorize confinement for an additional period not exceeding
30 days.
Yes. Furlough order. Order allowing a defendant to leave the facility not exceeding
14 days.
Right. but the commissioner may apply for a furlough order when a defendant is in his custody, pursuant to a commitment order, recommitment order, or retention order. And the commissioner is of the view that, consistent with the public safety and welfare of the community and the defendant, the clinical condition of the defendant warrants granting the privileges authorizing a furlough order. The application for a furlough order may be made to the court that issued the commitment order or to the Superior Court in the county where the secure facility is located. It can make that commissioner can make the application for a furlough order either where the commitment order was done, in the court where the commitment order was done, or in the Superior Court in that same county.
Oh, that's a good question, because I wouldn't have got that.
Where the facility is located in the county.
Yeah, I would not have got that, so that's a good question.
The Superior Court in the county where the secure facility is located. And the commissioner must give how many days written notice to the district attorney, the defendant, the defendant's counsel, and the mental hygiene service. All have to be notified of this thing that he wants to get a furlough order for this.
I don't know the answer to this, and I don't want to guess wrong and put it on the tape, so just say.
Okay, it's 10 days.
Okay.
He has to give, the commissioner must give a 10-day written notice to the district attorney, the defendant, the counsel for the defendant, and the mental hygiene service. I guess that he wants to give notice that he's going to apply for this furlough order, right?
Yeah.
And he's got to give that 10 days before what?
I don't know. Before the order?
It just says must give 10 days written notice. Let me look at the book. The application for a furlough order may be made to the court that issued the commitment order or to the Superior Court in any county where the secured facility is located. The commissioner must give 10 days written notice to the DA, the defendant, the counsel for the defendant, and the mental hygiene legal service. And upon receipt of such application, the court may, on its own motion, conduct a hearing to determine whether the application should be granted, and must conduct a hearing if a demand thereafter is made by the DA.
All right. So that's what they're notifying them for. So if they want to demand a hearing.
So I think, right, they're notifying them that they're gonna make an application for a furlough order.
Oh, okay.
So I think they got to give them 10 days written notice. Like, I got to say to you, Mary, this guy that's in jail, I'm gonna go to the court and apply for a furlough order so he can go home for 14 days.
And I'm the DA, and I'm gonna be like, no, I don't want to do that. So I'm gonna request a hearing.
Right, and I gave you 10 days notice before I made that request.
Got it.
That's what I think it is.
Yeah, I think so too.
I got to tell everybody that in 10 days I'm going to the court.
I don't want you to succeed, so I'm going to ask for a hearing and try to say he shouldn't get to go home for even one day.
And that's probably the reason why they got to know everybody, so everybody can get their ducks in a row and get to the court and probably oppose it or whatever.
Right.
All right, and the last thing says that if the defendant fails to return to the secure facility at the time specified in the furlough order, he shall be deemed what?
Escaped?
Exactly. Effective October 1st, 2018. 330.25, where the defendant is a juvenile offender or an adolescent offender who does not stand convicted of what? Upon motion, with the consent of the district attorney, the action may be removed to the family court in the interest of justice.
Is it murder in the second degree?
I believe you're right. Yes, it is. Murder too.
Okay.
Okay, so this is not a question, but I'm just going to read it because it's part of the same section that's effective October 1st, 2018, and I didn't know how to make a question of it, so I just did it. If the district attorney consents to the motion for removal, he shall file a memorandum with the court setting forth, 1, a recommendation that the interest of justice would be best served by removal of the action to the family court, and 2, if the conviction is for an offense of murder 2, rape 1, criminal sex acts 1, armed felony, specific factors which reasonably support the recommendation showing mitigating circumstances that bear directly upon the manner in which the crime was committed, and where the defendant was not the sole participant in the crime, that the defendant's participation was relatively minor, although not so minor as to not to constitute a defense. And last, where the juvenile offender has no previous adjudications or having committed a designated felony, regardless of the age of the offender at the time of the commission of the act, that the criminal act was not part of a pattern of criminal behavior, and in view of the history of the offender is not likely to be repeated.
All right, so let me ask you a question because I'm a little confused now. I thought that this didn't apply to murder in the second degree because that was what I answered before, but then when you just read those charges, murder was there.
You're right.
I don't understand.
I don't know, but it is there.
Ugh, whatever. I don't understand that.
It is there. I don't know.
Yeah, that's like, I don't understand that.
So the first question I said, where the defendant is a JD or a JO or an AO who does not stand convicted of murder 2, upon motion with consent of the DA, the action may be removed. So they're saying murder 2, you can't.
I know.
In that case, why didn't they put murder 2, rape 1, why didn't they put all of those in the first question?
That's what I don't understand about it.
It doesn't make sense.
No, it doesn't.
Fuck.
Ugh.
This
I
sucks.
hate that. I hate it when stuff doesn't make sense.
I know.
That's why I hate the CPL. Stuff in the CPLR makes sense. This makes no sense.
1st or the 30th?
Tomorrow's the 1st.
Fuck!
Yeah, tomorrow's the 1st. So what I'm thinking is
I think
tomorrow...
what you and I should do is finish the criminal that we're doing right now, and then I should finish my family tonight, the videos I need to complete, and tomorrow break out the civil book.
Yeah, so let's wrap up criminal, then we'll do our own thing tonight, and then we'll...
Yep. All right, ready? Moving on. If the court is of the opinion, based on the specific factors in the district attorney's memorandum, that the interest of justice would be best served by the removal to the family court, the verdict shall be set aside and the plea of blank of a crime for which the defendant is not criminally responsible for may be entered.
Guilty?
Yeah.
Okay.
I don't know why it's guilty, but it's guilty. And upon accepting any such plea,
which, yeah, because this makes no sense, because if we're talking about a non-criminal responsibility, it's not a plea, it's an admission. So, whatever.
Right, it's usually a denial, right?
Yeah, more stuff that makes no sense, but continue.
Okay. Upon accepting any such plea, the court must specify upon the record the portion or portions of the DA's statement the court is relying upon as the basis of its opinion, and that it believes the interest of justice would best be served by removal to the family court. And such plea shall then be deemed to be what?
A juvenile delinquency fact finding.
A juvenile delinquency fact determination. And the court, upon entry, must direct action be removed to the family court.
Yep.
Okay, so we know it's a the plea of guilty of the crime which the defendant is not criminally responsible for may be entered. Okay, 330:30. At any time after rendition of a verdict of guilty and before sentence, the court may order upon motion of the defendant a blank or blank the verdict or any part upon the following grounds. They may enter what?
I don't know.
The answer is, let me read it again with the answers in it. At any time after rendition of a verdict of guilty and before sentence, the court may, upon motion of the defendant, set aside or modify the verdict or any part upon the grounds that any ground appearing in the record which, if raised upon an appeal from a prospective judgment of conviction, would require a reversal or modification of the judgment as a matter of law by the appellate court. 2. During the trial, there occurred out of the presence of the court improper conduct by a juror or another person in relation to a juror which may have affected a substantial right of the defendant and which was not known to the defendant prior to rendition of verdict. And 3. New evidence has been discovered since the trial which could not have been produced by the defendant at the trial, even with due diligence on his part, and which in of such character as to create a probability that had such evidence had been received at the trial, the verdict would have been more favorable to the defendant. 3030.40. A motion to set aside a verdict based upon the grounds listed above need not be in writing, but the people must be given reasonable notice and opportunity to appear in opposition. True or false?
Does it have to be in writing? I'm going to say no, it doesn't have to be in writing.
That's true, correct.
And I'm going to say, yeah, reasonable. I don't know if they'll be that nice on the test and it's just put it like that, but I'm saying that sounds right.
We're up to 340, girl. Ready?
Okay.
340. Information also means what? Three things.
A simple...
In 340.10, it also means, and information can also mean, God, you had it right.
Simplified information,
Huh?
simplified traffic, simplified parks, and simplified environmental conservation.
No.
No, what is it?
So glad I gave you it like this, the question, because they put those as choices. I don't want you to get that one wrong. It's only three things. It can mean a simplified information, a prosecutor's information, and here's where they can fuck people up, a misdemeanor complaint.
Oh,
So if they say misdemeanor complaint, nobody's going to pick it.
I know, because this must mean that he consented to be prosecuted by it.
Right, nobody's going to pick it. So, information again means simplified information, prosecutor's information, or misdemeanor complaint by waiver executed, consented to be prosecuted. So,
Right.
it's, you know what I mean? It's only if he waives the information being filed. Okay?
Alright, so this is the purpose for 340, Article 340.
Right.
Okay.
340.20. Plea to an information other than one against the corporation must be entered in the following manner. Either orally by the defendant in person, unless the court permits entry by counsel upon the filing by him a written and subscribed statement by the defendant declaring that he waives his right to plead to the information in person and authorizing his attorney to enter such plea in his behalf. Or if the only offense is charged are what?
Traffic infraction or infractions.
Charged is traffic infractions. The procedure provided in sections 1805, 1806, 1807 of the VTL relating to pleas in such cases is applicable when appropriate. So that means they don't have to appear, they can just write the ticket and send in their money.
That makes sense, because that's what everybody does.
Yeah. 3. A plea to an information against the corporation must be entered by
Counsel.
4. When the sentence is agreed upon by the prosecutor and the defendant as a predicate to the entry of a plea of guilty, the court or the prosecutor must orally, on the record or in writing filed with the court, state the sentence agreed upon as conditions of such plea. True or false?
That's true.
Exactly. 340.40. Except as otherwise provided, the trial of an information in a local criminal court must be a single judge
trial.
Right.
That's not true.
Wait, I think it goes on. Let me just look at my answer key 1 second.
It's if you get
That's what my thing says. It says this, but you know, right above it, I says except as otherwise provided.
Yeah, it's only
Yeah.
for.
Yes,
Yeah.
I got it. Let me keep reading then. Except as otherwise provided, the trial of an information in a criminal court must be a single. It does say must in the book, though, by the way.
Yeah, but then
In
it goes
any-
on
it's-
to say.
But yeah, in any local criminal court, a defendant who has entered a plea of not guilty to an information which charges a misdemeanor must be accorded a jury trial.
True, except for New York City.
Except in New York City criminal court, the trial of an information which charges a misdemeanor, if the term of imprisonment is not more than how long, must be a single judge trial.
6 months.
Great. The trial of a person who is an eligible youth. What's the meaning of an eligible youth again?
16, 17, 18, I think. Is 720 on the test? I don't remember if it's in 720 or not.
Let me look at my announcement. Hold on. CPL. 720's on it.